Good evening. My name is Terry Moore. You know me as QSMX Pilot. We have Robert, Gerard, Jan, and Red in here. Several of us are NLA national coordinators. And we just wanted to talk about this paper that John has made. And you see it up on the screen right now. He hasn't filed it yet. It's going to be filed. And we're here to just kind of tell you why you should be looking at it. And yeah, we know it's 6 pages, but that's okay. It's worth the read. I want to read just the first paragraph, and then Gerard will explain some stuff. So this is a memorandum of law, U.S. Supreme Court, and the Amendment 10. The purpose of this memorandum is to clarify the judicial powers of the federal courts from the powers not delegated to them. A key issue and point that was a direct assault on Amendment 10, where the people are to decide through courts of justice, is abortion, which is a natural law issue and not a positive law issue. That was unconstitutionally adjudicated by the United States Supreme Court, which is an equity court governed by codes and statutes, which then brings the issue into its proper jurisdiction, a natural law court of record, adjudicated by the King's Bench, the jury, we the people, made up of 12 people who are to mirror the will of nature's God, answering to him alone. The United States Supreme Court does not have the authority to think like God's adversary, that they can change God's laws. Now, there was a lot in that paragraph, and I think Gerard wants to talk about these footnotes, which are spread around up here. And Gerard, should we start with natural law versus positive law?
Yeah, because like you said, there's a whole mouthful there. So go and always make sure to read the footnotes.
Okay.
So let's start with natural law, which is the laws of nature and of nature's God. Here men are subject to the will of God, with unalienable right at liberty from human law. At liberty from human law. That's important. So then footnote 6 is human law, which is codes and statutes and regulations. Here men are subject to the will of the government, with legislated civil rights, that is to say, as privileges that are granted or not by the government. So that's a pretty radical idea, but that's what this country was founded on, and that's what we're supposed to be running on, and that's what this paper is about. So,
yeah, the Declaration of Independence talks about the difference between natural law, the laws of nature and of nature's God. Go ahead.
And so anyway, you can read these memorandums, which are going to be filed in this case, and it's not a court case. It's being filed by the Unified Common Law Grand Jury, and basically we've already made a ruling, and this is telling them that you have this and this problem, and it needs to be straightened out. There is no court case going on. The people have spoken, and that's what this is about. These memorandums that back up our core wanto that we filed some years ago. So this is pretty easy stuff to understand if you have just a normal reading comprehension, and the things that you don't understand are all in footnotes. So
and we'll be putting a link to this document and other documents down in the description of this, and also a link over here. Okay, so don't get bogged down by, you see this and it says all these numbers in New York and all of that stuff. Any of that case law, or almost any of it, can be found over at the LII, the Legal Information Institute, which is done by Cornell Law School. Excellent reference. You can also do Google some kind of law thing they've got, and sometimes that's better, but I use this all the time, and you can find out what you need from there. You can find these cases from there. But back to this guy, look for it, dig it. You don't have to understand every single thing, but if you want to and you're ready to, you can go back and read the cases and see if it says what we're saying it says.
And that's called shepherdizing the case, and which is a a requirement when you file a federal case. If you quote any law, they expect that you shepherdized it, which means that it was a ruling from the Supreme Court, but that it was not turned over later on with a different ruling. And most of these things that we're talking about here at NLA and the papers we file, they're pretty much fundamental law, and so you won't find much of this stuff ever gets overturned. Not constitutionally anyway, I should say. It's pretty well established that these things, look at the high court has to be pretty pristine and uniform in its ruling, so it has to conform.
And all we're trying to do is get people to read and see what it's about. There's a lot more to this paper. It continues to go on for 6 pages. And there's quotes from Thomas Jefferson, and it makes a very good case. And it will be filed soon. We just want to get you started. And some of those links will be down in the description. Anything else anybody want to say?
But to get everybody's beak wet and go in there and start tearing this stuff apart, because it's very interesting and it reads easy. I think it reads pretty easy, most of it, and it has all the explanations you need. So with that, click on the link and go in there, and we'll be doing more. We have many of these. If you go to the site and see what we're filing, it's voluminous, the paperwork that's there. And this is all the stuff that needs to be done to save this nation right now. And people need to come up to speed because we don't have a lot of time left.
All right.
Anyway,
thank you, Gerard.
The language of Jefferson in that, but it's not so bad that you can, and it's common sense almost. It's cause and effect. It's very it runs according to it makes sense to your head when you do read it. So that's basically what this is, and we're going to end here because we're going to continue on. We have many other memorandums that are getting filed, and you should look at those and get to know them, because that will give you an education that you'll never get in school. Thank you.
Thank you, Gerard.
Very good.
You're welcome.